Thank you for having me. I'm was kind of excited when Suzanne asked. I don't get the opportunity to do as many of these as I would like to. Um, I'm going to talk today. Mike Kierstead described it quite well the other day, where I'll probably be at about 30,000 feet in terms of talking at a very high level about internal responsibility system and where Ontario's health and safety system and where our legislation came from. And I'm particularly proud of my little wee part of it and coming from this jurisdiction, because our health and safety laws are really groundbreaking. Typically, a lot of our laws look to other jurisdictions for best practices and then kind of piece it together. But this one was quite innovative. And it all came out of one very clever gentleman out of a small community called Cobeconk, Ontario, who really drafted it. So I'm just like to talk just what is internal responsibility system, just tell you how the legislation recognizes that, and being mindful of everybody's time and their tolerance for missing their dinner. I will delve into talking a little bit about some emerging issues in relating to dealing with COVID in your workplace that some employers have been surprised by. And that's dealing with work refusals and dealing with occupational illness amongst your workers as well. And then at the end, I'll answer any questions to the best I can. If you're from Ontario, I can answer from quite a place of strength. If you're calling or attending from another jurisdiction, my knowledge of your laws is probably fairly skeletal, but I might be able to help you out with some best practices. So now I'm going to find my presentation and I will share it with you. I can't tell if you're seeing my screen or not.
Yep, we see it.
You do? Okay.
I do, yes.
Excellent. Okay. All of my status bar and everything disappeared, but as long as people can see and hear, then I'm going to keep going. If you lose me at any point, please somebody, I don't know, text me or poke me or throw something hard.
I'll watch the chat box.
Fair enough. So I love a presentation where they already know all about me and can lead in, because it saves me having to introduce myself. But all of that is accurate. I did spend the better part of 2 decades doing enforcement work. And now I have the distinct pleasure of teaching other people to go and do those same jobs. And I take a lot of pride in that. And I'm grateful to have that opportunity. So to go back to, the way befores in Ontario, health and safety legislation is relatively new and a relatively new concept. In 1884, they took a stab at it, but it was really just an effort to keep children and females out of the workforce. So it provided the definition for what a child was and a young girl and a woman. And despite being a law, it really just made suggestions that they shouldn't be at work. There was nothing about safety. There was nothing about hours of service. Pretty archaic and really didn't serve a purpose. But in 1964, it was actually almost our first evidence of due diligence, supervisor due diligence. There was construction activities taking place underground, digging tunnels in Toronto. And they'd had a number of collapses, and they had a number of gas releases, gas leaks, and some very close near misses and injuries, but nobody was killed. And the supervisor of the day went to the principal who was responsible for building this and said, we need to implement some new measures. It's going to cost you a little bit, but we're going to have to slow down production because somebody's going to get hurt. And for that gentleman's trouble, they fired him and they brought in another supervisor. And that person also very quickly identified safety concerns in the workplace. And that person was subsequently dismissed. So Supervisor 3 learned what was needed to be said. And basically, if you wanted to keep your job, you said nothing. And a very short while later, there was a collapse and a fire within the tunnel. And it took the lives of 5 Italian men. recent immigrants. It was predominantly Polish and Italian workers in this project. And those communities in Toronto took to the streets. This is crazy. This shouldn't happen. We need stronger laws. And out of that came an Industrial Safety Act. It was, again, pretty skeletal, but it did contain provisions that the employer ought to provide reasonably safe working conditions. So it was a start. Fast forward to the modern version of what we have today and what we know as the Occupational Health and Safety Act. And its roots came out of Dr. James Ham, and he was an engineer from the Cowaconk area, studied at MIT, became a doctorate through there in engineering. And uranium miners were developing silicosis, severe respiratory ailments. And Dr. Ham was commissioned to do a royal commission examining what was happening in these mines and to make some recommendations. And being a person who was very thorough and very meticulous, what he wrote didn't just focus on mines, it focused on the health and safety system across, well, I mean, it has global implications, but his focus was predominantly within Ontario. And he pushed this out. And the government embraced it. And the legislation that came out of it, most of the verbiage is directly out of his commission report. So I have a truncated video. It's usually about 30 minutes in length. And I've just spliced about 3 or 4 relevant minutes from it. It's produced by the Workplace Safety and Insurance Board. And it really talks to the role of senior management and the other pieces of the workplace parties in terms of health and safety in the workplace and the internal responsibility system. So I'm just going to bring that slide up here in a second and we'll walk through that.
What we obtained by visiting international leaders was a sense of how their responsibility systems operated, how the miner, the management, the training, the inspectorate, and their compensation systems all operated as a unity to lower the risk in their operating workplaces.
The central point is that safety is an integral part of all aspects of the operation. That's the simple central idea. It's integrated with issues of profitability and productivity, and then in the way work is organized, the way work is carried out, the way equipment is maintained, the way technological change take place, all happens with safety and health as an integral part of the consideration, not as just something that's off on the side from productivity and profitability, but it's integrated. And that's a simple idea. And whether it works or not depends on whether there is that simple conception carried right down through the organization. And I say carried down through because it has to start at the top and go right down through to the person working under a first line supervisor.
Ask what is the most important thing coming out of the mine? And in his view, it was the miner. Ham saw the miner as being key to the way in which the whole system should operate. He also saw that it was very, very important that the risks be identified and controlled. And among the factors that determine risk is the role of management and supervision. And he was very critical of the way in which the old mining industry addressed the manner in which they dealt with their miners and the way in which they identified and controlled risks.
You cannot deal with health and safety integrally by just having people come in and inspect the place. If there isn't a spirit within the place that represents a commitment to health and safety from the top down, doesn't matter how many inspectors you will have an unhappy situation. So the inspectorate is complementary to this internal commitment to safety as a as an integral factor with productivity and profitability right through the organization. Boards of directors spend 99% of their time concerned with issues of finance, of profitability, technological investment, capital investment. But if the board doesn't take an active interest in how the enterprise is performing, not just in profitability, not just in productivity, but in health and safety, then the signals, the evidence of a central concern for an integral concern for safety just isn't there.
I have a lot of respect for that gentleman, and the more I worked in health and safety, the more those things became crystal clear. There are parties that I'm going to get into. The legislation divides responsibility amongst recognized groups within the workplace, starting at management and ownership and trickling down to workers. And invariably, the workplaces that I found had a significant number of injuries or complaints, worker unrest, those sorts of things, that system was broken. One of those tiers wasn't really towing the line. More often than not, it was at the supervisory level, but it did happen. So within Ontario's health and safety legislation, and I have truncated this a little bit, so I haven't given you cut and paste verbatim sections from the legislation, but I'm trying to hit on some of the high points for you. We divide and provide responsibility legislatively to the workplace parties. And at the top of that tier is employer, or in the construction sector, they refer to them as the constructor. Now, employer could be an individual in a small business who owns and runs, and everything there is his or hers, and the workers come directly under their care and control. It could be a board of directors. It could be a CFO or a CEO. It really ultimately depends, but it's whatever the upper echelon is within a workplace or within the workplace. I've had rather unpleasant workplace events that I had to investigate where charges ended up coming of it and we were going to court. And it was the CFO that had to come to court and stand on the stand. And when the justice of the peace read out the charges, it was that gentleman who had to stand there on behalf of that municipality and plead guilty. Now, that was a workplace that didn't have a particularly healthy internal responsibility system, but I got to tell you, after that, it got a heck of a lot better. That gentleman I know from other people in the workplace went back to his offices, and he'd not been particularly connected to their health and safety programs, and really had sort of pushed that off as something he paid people to do. And he gathered all of his management types and executives and various high-level municipal people in a boardroom, and in no uncertain terms said that whatever it took, he was never, ever, ever going to do that again. And they got better as a result. It's unfortunate that quite a serious accident had to be the thing that got them there, but it did serve that purpose. So the employer's responsibilities include just basic providing instructions to workers, and that could be something day-to-day, or it could be formalized training. You're probably familiar with WMIS training. Many workplaces do it, and sometimes it's well understood and sometimes it's not, but it's quite common. Some workplaces will provide first aid training to their workers, depending on the nature of their work. But then you really have to look within yourself and within your organization to say where you're going to get the most bang for your buck. Where, based on risk, are we most likely to have our injuries? If you're predominantly office bound, perhaps it's just something as simple as office ergonomics. Slips and falls, those sorts of things. If a financial institution that actually handles paper money might be concerned about violence and theft, and they're going to provide some training and programs in that way. The employer is required to provide health and safety policies and programs, and depending on the type of work that you do, they may or may not be required to be in writing. However, it's legislatively, they may not need to be in writing, but if you have to prove that you have these things, it's pretty tough to do unless they're written down somewhere. The employer is responsible for providing competent supervision, and competent means somebody who's able to organize the work, understands the risks associated with the work, and understands the health and safety legislation that applies to the work. So it's a three-part test. Now, that person doesn't have to be a separate body. If it's a small-ish work environment, then the employer could wear both hats. However, in larger organizations, we tend to download these things, and the person doesn't have to have the title of supervisor so much as they have the duties of a supervisor. I've heard them called team leaders, key holders, forepersons, commanders, lieutenants in law enforcement. It really depends, but it doesn't matter. It's ultimately, what do you do? And if you have responsibility over workers, then you're probably fit the definition for supervisor. Employers are responsible for providing equipment that's safe and maintaining it once you have it. And again, I'm truncating things and making them shorter, but ultimately the employer bears responsibility for making sure that the act and the applicable regulations are carried out in the workplace. So that's their duty. That's their piece of the internal responsibility system. Those are their responsibility. And if they do that and they show a commitment to that, we've satisfied one of three sections quite handily. Now, supervisors, again, there's much more within the legislation, but when it really boils down to is they're the safety police. The Ministry of Labor is not the safety police. Dr. Ham put it well. It should not be the inspectorate that makes a workplace safe. It doesn't work because there's only so many badges out there and only so many sets of eyes. And a lot of workplaces will take the approach, I'll do it when they make me. So the legislation acts sort of contrary to that and forces or puts a structure in place where this internal system has the ability to work. So supervisors, they advise workers of known hazards in the workplace, and they enforce employer policies and programs as well as the legislation. And that's kind of an interesting piece that some people don't understand, is that the employer trains its workers, the employer examines its risk, and the employer develops programs, safe work procedures that the workers should follow. And once the employer puts those out there, once the employer says, when doing job X, our expectation is that workers will do it in this fashion using this equipment. Once they've codified that, once they've developed those things and communicated to their staff, they take force of law. So a worker is required to work in accordance with the employer's policies and programs, even if those policies and programs go beyond legislative compliance. And I would argue that most policies and programs should go beyond legislative compliance. The Green Book that we use is the minimum. There's a lot more that people need to do and ought to do. And by the employer developing those things, they're in essence creating workplace law. And it does have force of law, and a supervisor's responsibility is to make sure that that's happening in the workplace. So that's their middle role. And I can tell you, in probably 70% of the workplace fatalities, and I unfortunately had the task of looking at a lot of those, and workplace critical injuries, so in essence, a serious event that could have just as easily caused death. The fall down point was that supervision. A supervisor doesn't have to watch the worker every minute of every day, but they absolutely have to make sure to the best of their ability that rules are understood and followed in the workplace, and issue progressive discipline when they're not. And that's that big piece of due diligence. And that's really where the employer and the supervisor, the due diligence is in the legal term is took every precaution reasonable in the circumstances to prevent the commission of an offense. And this is where there's an awful lot that a supervisor ought to do. So when people take on that role, they go, I get a shift premium, I get a few more bucks, I get to boss some people around, I get a little office in the corner, life is good. But what they don't always understand is the burden that they've just taken on to themselves in terms of legislative compliance. It's not a tremendous burden in the case of like an administrative type workplace, but if it's anything production related, manufacturing related, retail, a lot comes with that. And finally, workers. And workers, obviously they're the lowest tier in terms of responsibility in the workplace, but their responsibilities predominantly are follow the law, follow their employer's programs, participate in the training, and report any unsafe working conditions that they're aware of. So they don't supervise each other. They really just have to care for themselves and obey the policies as written. And that's done. I can guarantee without supervision, that will not be done well. Very few workers take that burden on themselves. But if you get a culture in your workplace where the employer writes reasonable policies and communicates those very well and provides training and supports people in implementing them and buys good equipment and makes sure it runs well and gives competent supervisors, that becomes a cultural thing. And workplaces get safer, and you don't end up on the radar of Ministry of Labor when you have that healthy system in your workplace. And if one of those levels it's not working, really good chance you're going to see a member of the inspectorate. And I just pray that it's not because somebody's been hurt, because that's usually where it manifests itself. And I know so many organizations right now are just hemorrhaging money. Those others are doing okay, but it's a tough gig to make a dollar right now. And the measures required to work safely in COVID cost. You've got to have more people and greater separation and longer and disparate hours because you're only allowed to have so many people in at one time, and that costs money. And what I've seen in the past is when money gets tight, health and safety is one of the first things that gets cut. And albeit biased, I think that's a little short-sighted, and it usually costs them much more in the long run. You're now down to 6 workers where you used to have 8, so you've kept your 6 best, and one of those 6 gets hurt. How do you make up that skill set and that work? You ultimately can't. So that's not the place to make tremendous cuts. But again, I'm biased. There's one interesting section of the legislation, and I deliberately put pictures of clay here. My students at the college, I call it the Gumby clause, but here I use modeling clay. The legislation has 2 sections, one for employers and one for supervisors, but they read verbatim. And it says the employer should take every precaution reasonable for the protection of a worker. So law is very, very slow to change. Usually it takes a crisis. And when we get a crisis, typically what we get from that is very poor law. And I think, in recent times, we've seen some efforts made by our leaders to create law to address issues. And then immediately the blowback shows major holes and gaps in that law. So well-written law takes a long time to get out there. Health and safety law is very slow to change. They wanted to change the stuff relating to confined spaces, and it took 11 years to write the regulation. But that doesn't mean the world stays static, right? The hazards change, pandemics arrive, other things, and the ministry is always right on the cusp of that, because if there's some sort of a wave of issues or initiatives that we hadn't thought about before, they're still asked to deal with it. But they don't have the law. If the law is silent on a matter, but they do have this section, and this section is brilliant. And if you look at recent media releases where some of these large box stores were charged because their COVID precautions weren't deemed good enough for the protection of workers or protection of the public, the inspectors went in, and this was the section they wrote orders under, because the Green Book, the Occupational Illness and Safety Act, never considered COVID. When they wrote this back in the 70s and early 80s, this was not something that was on their radar. So the law is woefully inadequate, but we still have this. So if there's a hazard to a worker and the law is silent on it, the legislation still says, Mr. or Madam Employer, Mr. or Mrs. Supervisor, you still have to take every precaution reasonable to protect your staff, to protect the people under your care from this new and emerging thing. And when you looked at the news stories, you will see that box store X was inspected on the weekend and received 4 orders to take every precaution reasonable to the protection of the workers. So they leaned on this section. Prosecutions too typically come under this, and it's tough. This is again a due diligence thing. How do you demonstrate that you took every precaution reasonable after the fact? If there's been an injury or an event in your workplace, it's quite obvious. In retrospect, hindsight's 2020, but prior to these events, what did you do to prevent this? And that's the question that people have to answer predominantly when they've had a negative event. So that is a brilliant clause. There's only one other piece of legislation in the province, the Environmental Protection Act, that has anything like it, and it's not nearly as strong. And other agencies would give their left arm to have something like this. It is really, really good, and it gets used. But I use the example of the clay because the inspector and the ministry can kind of mold this section and fill it in cracks where the legislation is silent or where the legislation doesn't speak to a particular issue, even though we have a known hazard. So in the absence of law that deals specifically with the thing, they use this section, they use the Gumby clause, they use the modeling clay to fill in those gaps. A really quick thing before I move on from this one is modeling clay cannot be used to change law. So if the regulation says something should be done like this and an inspector felt that was inadequate, they can't use this general duty clause to replace, to supplement that legislation. That's not permissible, and that would not be appropriate or defensible at tribunal or in court. So it's only where the legislation is silent that this should be implemented. So the internal responsibility system and the legislation, it adds a few elements, and this is again quite high level, but it requires the formation of joint health and safety committees, and that encourages that dialogue and participation between ownership and management and workers. And if the workers are represented by a trade union, the union decides which workers will sit on it. But they have meetings. They engage in dialogue, and in a healthy workplace, policies that are being developed, it is an employer responsibility to write them. But if they engage their joint health and safety committee, now you've got worker buy-in. Workers have had the opportunity to review and comment and make suggestions for change. Yes, it's still the owner's responsibility or the employer's responsibility to put pen to paper. But if the content came from an effort amongst all the workplace parties, you're going to get a lot more buy-in. And that's great. Workplace inspections are done. Now they're required to be done by a worker, but again, in healthy workplaces, a manager will accompany them monthly and just do a physical walk of the workplace. And there's criteria for that. Creation of policies and programs is embedded right in the legislation. And in a smaller workplace, they don't put this burden of a health and safety committee on them, but there still needs to be one worker, one non-management rep that takes the hat of the worker health and safety rep and does an inspection of the workplace at regular intervals and provides feedback to the employer and is sort of a peer advocate and a go-between the employer and some of the workers. So the legislation gives you a vehicle and a structure for folks to talk and communicate and share ideas and share best practices and implement change and identify risks and fix them. So it's pretty brilliant as long as you follow it. If you don't follow it, then you're probably going to be in a bad place at some point in time. There we go. So that's a very high level look at the basic foundation of the Occupational Health and Safety Act. It's to teach the contents of it and the nitty gritties and the exceptions and look at some of the case law. But that's a pretty deep dive, and it takes many hours to get through. So it's not something for a 1 hour evening chat. But if somebody needs that sort of information, well, there's many resources out there that can help you get it. But I did offer to talk about a couple other subjects tonight that may or may not be timely, given the circumstances, and given that now that we're getting shots in our arms, some employers that told everybody to go home to work are slowly trying to bring them back. And I think a lot of those people have kind of gotten used to working at a distance. and maybe a little bit resistant, and probably still have a bit of fear. There's so many conflicting news stories that it's hard to know what's true anymore, or what you ought to give weight or credit to. Like if I've had one shot, am I protected? If I need two, how many weeks do I have to wait? If I'm not sick, can somebody else get sick? So there's a lot of unknowns. I was talking to Ministry of Labor inspector today, as a matter of fact, and their reactive work dealing with work refusals has gone just through the roof. So I'll tell you what happens at the employer level. So workers within the legislation, entrenched in their rights, is the right to refuse unsafe work. Now, there's criteria for that, though. It's not just I refuse. There has to be a rationale or a reason. And it could be that equipment, machines, or devices are inadequate. It could be that a physical condition of the workplace is likely to endanger. And more recently, back about, I guess we're about 9 years now, so maybe it's not that recent, we added provisions for somebody to refuse work if workplace violence was likely to endanger themselves as well. So those are really where a worker, if they thought they were at risk, could align their concern with and refuse work. So in terms of physical condition, these pictures always give me brief nightmares, but I would hope that this person down in the trench, well below grade, no slope, heavy equipment operating on top and actually dropping a load, if that person came out of the hole and said, I am not going down there anymore until we change how we do our work, I think if I were still wearing my inspector hat, I would agree wholeheartedly that satisfied an unsafe working condition. The physical condition of the workplace posed a risk. This was another one, and actually the workers in this one, this is a boiler in the basement of a movie theater, and what was stored down there was cans of pop, and young workers were being asked to go in and out and grab cans of pop. And this, I don't know what your level of appreciation for asbestos is. I think we all know it's bad. But it becomes especially bad when it's called friable or becomes airborne. And this stuff is breaking off in major hunks and forming little asbestos snowflakes all over everything, which are quite easily respirable. So, once we discovered that was asbestos, nobody wanted to go down there. And I 100% agreed with them that needed to be remediated before that space could be used safely. But what about this fella? Could COVID or the risk of COVID exposure be considered appropriate to satisfy the conditions for work refusal? Is COVID in the workplace or the potential for COVID in the workplace grounds for work refusal? And the answer is far more complex than that. But I would say generally no. The possible presence of a droplet virus or something that you can pick up from touch surfaces, you need to know it's there. You need to know there's a presence. So it doesn't quite fit the criteria. Now, if I share a cubicle with another person, I'm not issued a mask, the ventilation in my workplace is terrible, that person isn't wearing a mask and they're coughing and sputtering and exhibiting all of the symptoms of COVID, that dramatically changes the scenario. But in a workplace that issues PPE, respects social distancing rules and public health guidelines associated with it, wears masks, eats in separate designated areas, and does those things that our medical experts are telling us we should, and there's no known cases within the workplace, just fear of COVID would not satisfy the criteria for work refusal. So it doesn't reduce the worker's right to refuse, but ultimately it's not going to be successful. So let me walk you through how these things actually play out in your workplaces. And I don't know if any of you had one before, but I hope it's somewhat interesting. Oh, sorry, I'll talk about just briefly that some workers have an inherent risk in their work. Police officers, firefighters, correctional workers, hospital or care workers, those sorts of folks. They knew or they ought to have known when they agreed to go and work in that place, there's a certain level of risk associated with their work. A police officer, fully armed and equipped and trained and ready to go, could not refuse to go to a domestic disturbance because somebody in there had a knife. Well, that's unfortunately what we pay you for. And that is a realistic expectation of your job. So they might stage up and wait for backup, but that's not a refusal. That's just implementing safe work practices. But to just say, no way, no how, I'm never going, doesn't cut it. Same as a firefighter can't say, I'm not going in there, the building's on fire. Well, it's kind of your job, so you do. Correctional workers, they can't say, this place is full of bad men and women, I don't want to go in there, they're dangerous. Well, tough. That's the nature of the work, and if you feel that strongly, maybe you need a career change, but it doesn't satisfy the criteria for work refusal. Now, change that a little bit where there's an inmate, they have an edged weapon, there's nobody else is at risk, the guard is not equipped or does not currently have their personal protective equipment like Kevlar shield with them, and they refuse to engage that offender until they have backup or appropriate protective equipment, that would be appropriate, that would be possible. So there's these limits on who can refuse and when, and essentially if it's inherent in your work, you're expected to still do it. So a worker identifies that there's an issue where they feel unsafe and they refuse, is the first step. The worker, and this is what should happen in all of these, is the worker should go to their supervisor, and the supervisor hopefully investigates, works with this concerned worker, and comes up with a resolution that is supported by the worker. The worker's satisfied. The supervisor replaces the guard or gives them a piece of personal protective equipment that should help deal with the issue. And as long as the worker is satisfied, they return to work and it's done. The refusal is essentially over. At that point, it's really more of a concern than a refusal. But sometimes the worker reports something and the supervisor has a very different opinion of the matter. The supervisor says, I'm sorry, I don't see this in the same way you do. I don't perceive this to be a hazard. If that's the case, the worker is assigned other work in the workplace or is moved to a safe place if there is no other work in the workplace. And this is where the internal responsibility system engages. So the supervisor should then bring in some worker member from the Joint Health and Safety Committee. It could be the worker health and safety rep or some other member that does not exercise managerial function from their committee, from their group, to look at the issue collectively with the supervisor. So now we have two people that are looking into the concern from the worker. And it is possible to assign another worker that task as long as that other worker is told there is a work refusal currently for the following reasons. And if the worker doesn't share that same concern, they can do the work during the investigation. Most oftentimes they won't, particularly in a union environment, they won't, or at least that's been my experience. But so now we have a worker rep and a supervisor that are looking into the concern and trying to come up with a solution. Now, hopefully through their joint investigation, they come up with a solution. They take it back to this refusing worker. The refusing worker is satisfied with their resolution and goes back to work. And once again, this is really just a complaint that was dealt with in the workplace. The internal responsibility worked like a charm and everybody goes back to work, problem solved. Sometimes that joint investigation doesn't come up with a resolution. Sometimes the supervisor and the worker rep are at loggerheads, or sometimes they come to a mutual agreement, but the worker still says, no, that does not satisfy my concern. And at that point, and only at that point, you must forthwith immediately contact the Ministry of Labor. And the Ministry of Labor have on-call inspectors. And I know in the GTA, for example, Greater Toronto Area, they regularly have 4. And my peer that I talked to earlier today said they quadrupled that since the advent of COVID because they were getting so many. So the after hours in Toronto has 16 labor inspectors at any one time that will answer 24/7 and will respond to work refusals. So this entire initial process is called stage 1. And stage 2 involves the involvement of the Ministry of Labor. And the Ministry of Labor will come right away. They will get in their ministry vehicle and they will attend your workplace and they will look into the matters and they'll render a decision. And that's this stage 2. But the first thing they want to know is, have you done stage 1? So the first thing that happens from the inspector perspective is they receive the call, they call the workplace, and they're going to ask you the exact words, have you done your stage 1? And if the answer is no, they're not coming. They'll give you a bit of education on the information I had in that previous slide, and they'll push it back on you. They want that internal responsibility system to be engaged. They want you to try and work things out internally first. And many times I never got a second call because they went through that process and figured it out, and they didn't need Ministry of Labor involvement. If stage 1 is done, the inspector is going to check the computer very quickly, because if this has been a previous complaint, sometimes you get frequent flyers, you get workplaces that their internal responsibility system is lacking, or sometimes they just have one worker that has a bit of an axe to grind, and they use this as a way to inconvenience their employer. So the inspector wants to know if that's the circumstance in this workplace, and then they'll come. They'll attend the workplace with all the relevant parties. Typically, inspectors approach it trying to get people separate, and they want to hear everybody's perspective on a particular issue, and then they'll bring them all together. But at the end, the inspector only has 2 choices. There's only 2 options allowed from the result of his or her work. And they come up with a decision, and the decision is either likely to endanger or not likely to endanger, and that's it. And if it's likely to endanger, that means the inspector is telling the employer and all the workplace parties, the situation that represents this work refusal is an imminent hazard to the health and safety of workers. And if they determine that that's the case, they're going to give you orders to fix the problem. And generally those are stop work. So if I say something is likely to hurt somebody, there's an imminent risk, I'm not going to get back in my truck and let somebody else do that task. I'm going to make some changes. However, it's not likely to endanger. The worker who has refused work needs to go back to that job. Their refusal has been dealt with and is over. They cannot continue to refuse. Some employers said, well, he still won't do it, and it's no longer a labor issue. It's now an HR issue, and your progressive discipline would have to take over at that point. If somebody's refusing to do work that the ministry has deemed not to be a risk or an imminent risk to their safety, they have to go back to work. And if not, it would be like any other task they refused to do. You have to deal with that internally. So that's all that's going to be on the report at the end of these things. So if you think about this in the context of world events right now, people are concerned about this virus that could be anywhere and everywhere. And we hear stories of, I did all the right things and I still got exposed. And there's a lot of unrest, and the number of places that are exploring work refusals, and the number of people that at night are going, oh my God, I have to go back to the office tomorrow. I'm so paranoid. And they go online and they search health and safety, and they search and they discover that there's this wonderful tool called a work refusal, and I'm going to do that and I won't have to go to work. And it's creating a tremendous amount of work for the ministry. But I think if employers were better educated on the process and the criteria, they might be able to deal with these right up front and help educate their workers a little bit about what is and what isn't, and where they should explore these sorts of things. So that's just a Cole's notes on those. I'm just checking my time. Okay, so I think I've still got about 10 minutes, which is probably perfect. I think that's right where I want it to be. Occupational illness is the next small piece that I wanted to touch on. And again, we're sort of talking much higher. I could delve into this for hours and tell you all sorts of ugly stories and show you lots of pictures. But essentially, occupational illness is a condition that results from exposure in the workplace to a physical, chemical, or biological agent. So if we're talking COVID, we have a biological agent. And if somebody gets sick, their physiological mechanisms are being affected. And the work is impaired. And if that happens, if a worker develops occupational illness, and it's not just COVID, healthcare had known about the reporting requirements and the definitions for occupational illness for a long time, because they have influenza outbreaks, they have scabies outbreaks, which becomes a biological agent. They have respiratory disease, they have gastrointestinal disorders. They're exposed to a lot of cooties in that work, and they have practices to mitigate those things, but sometimes they get a little bit complacent, and or their employer isn't giving them the necessary tools and training. But if occupational illness happens and the employer becomes aware of it, or the employer becomes aware that a worker has filed a claim with WSIB, there's a requirement for the employer to tell the Ministry of Labor that this has happened. And it doesn't matter whether you agree with the worker or not. It's just the mere fact that you've been told that I've gone to WSIB, I got COVID at work, I'm sick, my family's sick, and it all happened there. And whether you go, well, wait a minute, you were on vacation for 2 weeks and you worked from home for the 2 weeks before that, how could we possibly be responsible? Doesn't matter. I mean, ultimately, it will come out in your favor. But at the outset, you still have to tell the ministry within 4 business days. And the criteria for what to report are found within the legislation. It's pretty basic stuff: the name of the worker, the name of the injury, what have you done to prevent a reoccurrence, those sorts of things. And you may or may not get a Ministry of Labor inspector to that. Now, it is important to know that if you're being diligent in reporting, so somebody calls in and says, I felt unwell yesterday. I went for a test. It's come back positive. I feel flu-like symptoms, but I'm not at death's door. I've been ordered to quarantine. I'll keep you apprised of that. That doesn't necessarily prompt reporting. Reporting comes when there's a logical nexus between a workplace exposure and the worker's illness. So if they've been in your workplace and there were other cases that came out, one might reasonably say the exposure happened in the workplace. But in my other scenario where they were gone for 2 weeks and working remotely for the 2 weeks prior, we know about the incubation period. We know about symptomatic and exposure and things like that. And there's no nexus. There's no tie between the workplace. So in terms of proactive inspection, or disclosure to the ministry, you wouldn't have to do that unless they had filed a claim with the WSIB. And ultimately, at the end of that one, there'll be a small investigation, and they'll determine that it wasn't the result of a workplace exposure, and thus it will go. Other workplaces where this happens, though, is police officers will report occupational illness from doing firearm training on the range. After 25 years of shooting their gun a couple times a week, they could suffer hearing loss. Municipal workers have been known to develop nervous disorders in their limbs because of the vibration of equipment and those sorts of things. And those are all occupational illness. And some of them, like mesothelioma from asbestos, they can take place. You can be retired 10 years and get sick. But if you look back, I knew I had a public school principal who the area where they kept the gym equipment in his school and the chairs for assemblies was under the stage. It was completely lined with friable asbestos. And he would go in and retrieve the sports equipment and the chairs, and 10 years later, or 10 years after retirement, got quite sick. It was still deemed to be occupational illness. There was that logical nexus from an inspection, or from an exposure rather, that happened ages prior, but there's still a reporting requirement. I just want to share one more small video that if you're looking for health and safety resources, Ontario's pretty good, but in terms of free online stuff, I can't say enough about WorkSafeBC. There's a piece here that talks about or indirectly, but deals with internal responsibility and the view from a small employer. Come on.
My name is Mike Honeyman. I'm the regional manager of the Arctic Aero Powerline Group in Cranbrook, British Columbia. I started with aero installations in February of 2006 as an engineering technician. And in 2008, I was offered the opportunity to buy into the company. And my wife and I chose to do that. At that time, we bought basically 1/9 of the company. We came into it thinking not a lot of people would have this opportunity at this stage in their lives to get into something like this. When we bought in, the company was growing, and we were very excited for the future. Things just divvied themselves out based on what needed to be done. I took on that role of developing the Occupational Health and Safety Program for our company. I was actually pretty excited about doing that. I spent a lot of time at it. I added all kinds of awesome pictures, used nice fonts and different colors, and made this nice title page and signed it off. I felt very proud of that. I've been an owner at Aero for just over a year, and Mike Russell was a sub-foreman. I didn't actually know him very well. He was, one of the guys, a relatively new employee, and there was a lot of them. He was working on a high voltage line, had climbed up a pole when he was electrocuted. It was 14,000 volts on that line, and he was encompassed with a ball of flames. The electrical arc lasted for quite a while until it broke, and he fell away backwards, unconscious, up on the pole. He was rescued by the apprentice he was with and the hydro crews that showed up, flown to Calgary, taken to the hospital. It was a long period of time, again, where you didn't know if he was going to live or die. I can't imagine what his family was going through at that time. It was awful, really awful. And it was scary. Coming in the morning and gathering everybody around, people are wondering, well, is he going to be all right? Is he conscious? I don't know. I don't know what's going on. And, they did their best to do what they could, but as a result of the injuries he sustained, he lost his arm and his leg. When something this severe happens, the investigation is right now. So you have people coming in, WCB, you've got the investigator, and there was an ex-RCMP guy that was part of that. And that's stressful. It's a tough thing to be sitting in the middle of, and you're getting asked a lot of questions that you don't have a very good answer for. Everything about your company is exposed and vulnerable. And it doesn't matter how much good stuff you did. It's the things you didn't do good they come to the forefront, and they come quick. And that hurts, especially, when you're proud of something and you don't really think that you did a bad job. Then this happens, and then you realize, yeah, I actually did do a bad job. And now it's out there for everybody to see. And you got a family that's just devastated. Their lives are changed forever. You got a company that's in jeopardy of losing everything. And it was tough to maintain a cohesive unit as an ownership group when that was happening, because you still have to make sure that the business is running as best as it can. You got to take care of the people. You got to deal with community, all the stuff that comes with that. I'd get phone calls from people while I was at work, even while I was at home. I'd run into people that I hadn't seen in a while, and they'd be like, what went wrong with your company that you guys became this, where you got a guy that's life has changed forever. You don't care about people. It's based on the message I got. Your business is in jeopardy when something like this happens, and how you react to that is going to kind of define who you are as a person. And you gotta just realize, okay, this is either an opportunity for us to fail miserably as a business, or we can just accept what this is and try and work through it and try and come out somehow on the other end and see where we end up. As far as the Occupational Health and Safety Program went, and that was a big submission with the investigation. And what I learned from that was I actually did do a good job on covering off the legislation required. Everything that was in there in that book was in there. The book was good, but what I learned was that it doesn't matter what you have written down in a book if that doesn't translate into something real with the people that you are responsible for as a business owner. It means nothing. It's about connecting with people and really showing them that when you're talking about safety, you mean it. And what you mean is that you actually want them to be safe, and you want them to feel comfortable that they can make calls that, hey, something's going sideways here, let's shut her down for the day. Oh, this isn't working right. Well, let's go get it fixed before we try it. I honestly think if maybe I had approached it differently when I had the chance to, maybe it could have made a difference. I didn't do that, and huge hard lesson to learn. It wasn't long after Mike's accident that he was back at the shop here, and right away he said, I want to come back to work. And from 2009 when the accident happened to now, he's a foreman power line technician with us, but he also has a lot of other roles. He's our A-ticket guy with the safety authority. He deals with scheduling, estimating. He's doing really well. He's a huge part of the success of the company, and I'm happy to have him here. If I was talking to a business owner that was in my shoes, the one thing I would say is go and grab your people and sit down and talk to them about safety. Let them know that that really is something you care about, that you want to make a difference, and you want to do what you can to be part of them coming home safer every day. I was holed up in an office for a year and a half writing a book that did nothing for anybody. It was a mistake. Don't make that mistake. Go do what you can now, and hopefully you don't have to learn things the hard way.